Thank you all for joining. Thank folks in person as well as on Zoom. This is our Tenant Skills and Fair Housing Know Your Rights workshop. And my name is Kalia Livingston. I work with the Champlain Valley Office of Economic Opportunity with the Fair Housing Project as the Education and Outreach Coordinator. So part of the work that I do is teaching people about their rights and responsibilities under fair housing laws. And I also support our Vermont Tenants program at CVOEO, which focuses solely on housing education for tenants. So this is going to be a mix of information related to both landlord tenant laws in Vermont as well as fair housing laws.
Can I say one more? I've been consumed with this, so I haven't kind of introduced the couple of us. So this is brought here by the South Burlington Housing Committee. So every April is Fair Housing Month, and so because there's a large portion of renters take up about 40% of our community, and we want to reach out to renters in this community and also include them in some of the discussions about community services and housing and their housing needs. So my name is Nora Senecal, and I'm currently the chair of the Housing Committee. Sandy Dooley's also part of the Housing Committee. So thank you for coming out on this gorgeous day. And Kali has been just a great partner in getting this together. So thank you.
Yes, thank you to the South Burlington Housing Committee. It's been great to collaborate with you. And as Nora said, April is Fair Housing Month. So although I do these sorts of workshops any time of the year, they're more prevalent during April, and happy to work with any groups of people who might be interested in having one of these held for any organization or group that you're a part of as well. All right, so what we're going to get into in this presentation is identify legal protections under fair housing laws. We're going to help people recognize if they've experienced illegal housing discrimination, whether it's in their housing search or when actually residing in a space. We'll also talk about resources that people can use to seek help if they've experienced discrimination. We'll talk about building skills to communicate effectively with your landlord as a tenant. Also share the rights and responsibilities of a tenant and housing provider. We'll use resources and best practices to make sure that tenants are able to get their security deposits back, get repairs made, and talk about what it means to end a tenancy on both the housing provider side and the tenant side. And I'll also share other resources that we have related to all this content and where people can find this information again, and resources for getting interpreted or translated versions of any of the information that I shared. So one of the most important takeaways of this entire presentation is our Vermont Tenants hotline number. This is our Vermont Tenants program is a statewide program, and we support tenants all throughout Vermont, and they can reach out to the Vermont Tenants hotline with any questions related to information that's discussed today, or more specific questions related to their personal housing situation. We will have time at the end of the presentation for questions. However, I might not be able to answer every specific question that people have related to their particular housing situation. So this is a great resource to reach out for that information. And I should also note that I'm not a lawyer. So if anyone has any questions that are seemingly would need support of an attorney, or they need legal support, then I will say reach out to Vermont Legal Aid or to an attorney. All right, so to start, why is it so hard to rent in Vermont? Vermont, like most of the country, is in the middle of a serious housing crisis, and this means that it can be very hard to find and maintain safe and stable and affordable housing. The more information that someone has about their rights and responsibilities under Vermont statutes, the more successful they can be in their rental situation. The vacancy rate is how many apartments out of 100 are on average open and available to be rented at a given time. A healthy vacancy rate is somewhere around 5%. However, the most recent average in Chittenden County is less than 1% for a vacancy rate, and it's actually 0% for apartments with 3 or more bedrooms and affordable housing units as well. So people who seeking that sort of housing would likely have to wait on a wait list for quite a bit of time. There's also an extremely high cost for maintaining sustainable housing as well. The average renter earns $17.67 an hour, which could afford a rent of $919 if they worked a full 40-hour week. But in order to actually afford rent that we see at market rate, which is really difficult to find a rent at $919, they would have to work 1.7 full-time jobs to afford market rate rent. So that's almost 2 full-time jobs. That's just a little bit about the Vermont housing market. Now we'll get into a bit on what tenants' rights and responsibilities are under Vermont landlord tenant laws and fair housing laws. Tenants have a right to equal opportunity in housing choice and the right to rent and live in a home free from discrimination or harassment, which is the definition of fair housing laws. It's important to note that because housing has a huge effect on every aspect of someone's life, where they live determines where their kids go to school, where they might go to school, the ease of getting to work, healthcare, recreation. All of these things are crucial to where someone can live. Research shows that having access to affordable housing improves quality of life by saving the rest of money for better education, health, leisure, transport, and other essential things that a person might need to have a thriving life in their community. Having enough quality, affordable housing is good for the community as it builds community connections and support, and diverse and inclusive communities spur economic and social development. So that's why fair housing laws are important, so everybody has equal access to housing choice, free from discrimination. And just to note, the folks on Zoom, please feel free to ask any questions in the chat, and Nora can let me know if you asked a question. However, there will be time at the end for questions, so if you want to save them until after the presentation, that's perfectly okay. So there are several protected classes in Vermont under fair housing laws. There are 7 federally protected classes, and all states have to have enforcement for discrimination based on membership in these 7 protected classes, which include disability, race, sex, which also includes sexual harassment. Sometimes people experience a quid pro quo sort of opportunity or deal that housing providers might make to someone, which could be considered sexual harassment if it's in exchange for sexual favors. Skin color is also a protected class, national origin, religion, as well as family status. So all states in the United States have to have enforcement for illegal housing discrimination based on membership in those protected classes. And if people experience discrimination based on membership in those protected classes, there are several things they can do, including filing a complaint with the Federal Enforcement Agency for Fair Housing, which is the Department of Housing and Urban Development. Additionally, states can elect additional protected classes. So in Vermont, we have several. And those protected classes include immigration status and citizenship status, which is a newly elected protected class as of July of 2025. This was just recently implemented. And it is now prohibited for housing providers to require that people put social security numbers on rental applications, which has been shown to be a huge barrier for people with varying immigration statuses. So this was a big fair housing win, and I'm really grateful that we were able to enact this protected class. In Vermont, people in receipt of public assistance are also members of a protected class. So people who receive SNAP benefits or have housing vouchers, it could be considered illegal for a housing provider to say, I won't rent to someone with a housing voucher. Gender identity and sexual orientation are also explicitly named as protected classes in Vermont, as well as marital status, so whether someone is or is not married. Age is a protected class, and also people who are victims or survivors of abuse, sexual assault, or stalking. And folks with membership in that protected class also have additional protections under Vermont landlord tenant laws.
I'm not hearing anything.
Okay,
Oh, no.
all right. Yeah, I just had asked um her if she could hear, but town meeting says they can hear, so um um that's why yeah. So let me get into your volume. Um, can you to let me stop sharing for a second. I just want to butts with your um uh
If you turn your audio on, will that make it so people can hear potentially?
no, because it'll cause a feedback.
Okay.
Um uh so if you stop sharing, I can just take a look at your sound and double check that all the connections are there.
All right. We are just pausing the presentation to make sure that everyone on Zoom can hear. I apologize for the delay and difficulty.
Right, your audio's, let me turn up your audio. Hello, hello. Okay, so our audio's working. I just put our
Maybe you take the first speakers.
I know, but I know, but a second person online, I asked them specifically if they could hear. I sent them a message. So can Empress?
Yes, I can hear you now clearly. Thank you.
Oh, you're so welcome. Okay, thank you. And then Shauna, I was trying to send you a message. Is that better now for you?
Yes, I couldn't hear at all before, but I logged out and logged back in and now I can hear.
Oh, thank you.
Great.
All right, we got it. We got it. You guys are awesome. Thank you for speaking up and thank you for and letting us know. All right. So
I think we want to share that screen.
okay, and then
Yeah, from current slide.
okay. I'm just gonna get this up here.
Right here.
Here we go. All right.
And what do you see on the Zoom?
I see this. Oh wait,
You can try restarting the share from in here.
it's working. It's different. Yeah, it's not great on the Zoom, but oh it's mirroring here, but not mirroring there. So
You also joined in.
it is, but it's on mute. Yeah, yeah. Right, we just double checked the sound and, because people are having a little trouble hearing us, so then when we share it, it's actually coming out like this. So we just have to reshare it.
There's a couple of so you're not sharing it all right now, or you are?
We
Okay.
are, but,
Oh, but it's not advancing.
it's, the folks online are seeing that,
They're seeing that.
yeah.
Okay.
We just need to share a different window.
Okay. So from Zoom. No, I don't want to leave the meeting, but where is that screen? It's
You're
probably.
sharing the presenter notes screen and not the secondary screen.
Yeah,
Yeah. Okay.
so go up to my screen up there, do you think? Yeah, so we want to just stop sharing that. Right, and then we'll go down to the share again, probably. Right, and so what we need to do is maybe hit that one.
Yeah. And you guys can experiment with this.
There it is. Yeah.
Okay.
Yeah,
Good. And then you can get to your slideshow in any of these windows if you want on your computer.
Okay, and if I just hit the arrows, it'll still change.
Um,
Okay,
Yeah,
great,
yeah.
thank you.
Yeah.
Okay.
Hopefully it all works. There's another computer back here with you.
Yeah.
That's mine, which I don't think I need that right now. Thank you. I appreciate it. All right, we're gonna get back into the presentation. I really apologize for the delay. All right, so based on membership in a protected class, it is illegal for a landlord to refuse to rent to someone, make housing unavailable, set different terms or conditions or privileges for the rental. That could look like having a general credit score that they accept from someone, but then they see someone who has membership in a protected class, maybe they're a single parent and expecting that only renting to them if they have a credit score that's larger than what they generally would expect. Steering someone of a protected class to a different neighborhood or type of unit could be considered illegal housing discrimination. That could look like a landlord saying, oh, I see that you have small children. I actually have a building 3 blocks over that has lots of families in it, and there's a playground close by. Even if it's seemingly coming from a kind place, it could still be considered illegal housing discrimination because it is limiting someone's housing choice. So it's best practice for housing providers to make sure that they still continue on with the showing for whatever rental applicant has applied to see, and then also mention other options that they have available that they could also apply to. It is also illegal to make, print, or publish any notice, statement, or ad that indicates a preference, limitation, or potential discrimination. Fair housing laws do apply to statements and advertisements, so making sure that housing providers are using language that talks more about the property opposed to who they want in the property when advertising their properties. There is a difference between discrimination and illegal discrimination. It's perfectly legal to refuse to rent to someone if they don't have rental references, or maybe the best rental references, or if they have a criminal background, or if they don't have a credit score that is what the housing provider expects. Those are legal forms of discrimination. And it's also could be discriminatory.
We lost you again.
Right. So people with disabilities have additional protections under fair housing laws. One of those is being able to make a request for a reasonable modification. So a person with a D, which is defined as someone who has cognitive condition that covers lots of people to be considered disabled under fair housing laws. So people who identify as disabled under those definitions and parameters can make reasonable modification requests. And this is a request to make a physical change in a space. It often can look like someone requesting a grab bar be installed in a shower, or maybe having a tub taken out and a walk-in shower installed instead. What's considered reasonable is based on what's feasible for the housing provider. So if it is something that's affordable, as well as something that doesn't make a permanent change to the apartment. So someone living in a multi-story unit, asking for an elevator might be considered unreasonable, opposed to asking for a chairlift, which might be considered a reasonable request based on what is feasible to the housing provider. And who pays for these changes? If a housing provider receives any form of government funding, like a public housing authority, they would be responsible for paying for these changes. However, if they are a private landlord, they could put that cost on the tenant. And once the tenant moves out, they would be responsible for paying to remove that change and bring the unit back to its original condition. People with disabilities can also make reasonable accommodation requests, which is similar to a reasonable modification, but it's a request to change a rule, policy, or practice. This comes up frequently in relation to assistance animals. So if a apartment has a no pet policy, people might use one of these reasonable accommodation requests to have their assistance animal live with them. Assistance animals are not pets, so any requirements that a housing provider might have for a pet wouldn't be applicable to the assistance animal, which is considered either an emotional support animal or a service animal. For a reasonable accommodation request or reasonable modification request, a person with a disability can make these requests verbally, and it is up to it's the responsibility of the housing provider to follow up with the request. I always recommend that people put things in writing just so they can have a paper trail. However, it's not required that someone with a disability makes one of these requests in writing. However, the housing provider can come back and say, I would like someone who has professional knowledge of your condition to sign off on this request. So that's the right and responsibility of both the tenant and the housing provider. Some examples of reasonable accommodation requests can also look like someone requesting a designated parking spot. Maybe they have a general lot that's allocated for all tenants, but would like to have a designated spot that's closer to the entrance of their space. If they have mobility issues, they could use one of these reasonable accommodation requests to have a designated parking spot. Earlier, I said that being discriminated against or denied housing based on having a criminal background is perfectly legal. However, because people who are in recovery are considered disabled under fair housing, that definition under fair housing laws, if somebody obtained a criminal background based on activity to support their substance use addiction when it was active, they could use one of these reasonable accommodation requests to say, to ask if they could potentially have their criminal background overlooked or not considered in their rental application process. So what to do if someone experiences housing discrimination? They can contact CVOEO and reach out to the Fair Housing Project. I can schedule time to do a consultation with someone and talk one-on-one about their housing situation and help them decipher what could be considered discrimination, as well as do a rights review with them, and also make suggestions for best next steps, which could look like them starting to journal incidents of discrimination. So we talk about how they can best document what happened, who said what, when they said it, things like that. I could also potentially reach out to their housing provider and remind the housing provider of fair housing laws and what their responsibilities are. I could support a tenant with writing a letter to the housing provider or a neighbor or someone who has potentially reached fair housing laws. Or the person might be ready to take more severe action and they want to file a formal fair housing complaint, and I can support them with, I can assist them with filing that complaint or send the sources to do so. And they could file a fair housing complaint with the Vermont Human Rights Commission, as well as the Department of Housing and Urban Development if they were discriminated against based on any of those 7 federally protected classes. I could also refer them to Vermont Legal Aid as well if it seemed like they needed more legal support based on what they were experiencing. In this section, we're going to touch a little bit more on rights and responsibilities of a tenant under Vermont landlord tenant laws. So to start, we'll talk a little bit about a lease. A lease is a contract, which is a fee for service. You pay the rent and the landlord provides the place to live. Both sides have rights and responsibilities under the rental agreement. It's important that people read their lease carefully before signing it, as a lease is valid and binding once a person signs it and pays that deposit, and not when they move in. You can always call our hotline to ask about specific sections of a lease if something seems unreasonable. Anything that is a legal term of the lease cannot be enforced. However, anything that's not illegal can be enforced. So there can be some fees for cleaning or making sure that a tenant gets a professional clean once they move out. Things like that can be included in a lease. It's perfectly legal, and it's important that people are aware of what the stipulations are of that rental agreement so things don't creep up on them. A landlord also must provide a rental as described in the lease, and the rental has to meet local and state rental housing, health, and safety codes. All tenants have a right to a refundable security deposit. Security deposits are often used as the kind of insurance in case a tenant leaves the space with damages that haven't been repaired or any unpaid expenses. If the tenant does not leave the apartment with any damages outside of general wear or tear, then they have the right to get a full security deposit refunded to them upon moving out. The security deposit can be as much as the housing provider would like it to be. Unless someone lives in Burlington or Brattleboro, then the security deposit cannot exceed more than 1 month's rent. And it's important that people note that the security deposit cannot be used for last month's rent. So it's expected that the tenant pays rent throughout the entire rental period and then can receive their security deposit without any deductions if there's no damages or unpaid expenses left behind. It's important to document the conditions of a space prior to moving in order to ensure that someone gets their security deposit back, so they can move in before moving all their possessions in and take pictures of the walls and the floors and all of the appliances. And then upon moving out, once they move all their possessions out, taking pictures of the same parts of the unit again, so they have these 2 groups of pictures that they can compare and contrast in case the landlord unfairly deducts from their deposit. After moving out, the landlord has 14 days to send an itemized list of deductions to the tenant with the remaining deposit or no deposit, or send the full deposit back. Otherwise, they forego the entire deposit after 14 days. And if a tenant feels like their security deposit was unfairly deducted from, or maybe they didn't get a deposit back at all and are unable to communicate with their past housing provider, if they live in Burlington, they could request a hearing with the Burlington Housing Board of Review and bring in a third party to mediate that situation. However, if they're outside of Burlington, they can also start a claim with small claims court as well. We've seen certain tenants receive more than their security deposit back after using one of these methods to have someone mediate their security deposit situation if the housing provider willfully withheld their security deposit.
Can I ask a question?
Yeah.
Okay.
It's 2 parts. One is when the tenant pays a deposit, $50,000, and 2 years later, 3 years later, what is expected of the landlord? Does he invest that money in a bank and you get an interest of 2% or whatever the interest rate is? Do you get money added, or does it just go under his bed? You know, do you get interest earned on your deposit?
I know that in Burlington, the housing providers are expected to put the security deposit in an interest-bearing savings account. Outside of Burlington, I don't know if it needs to be an interest-bearing savings account or just in a savings account, or if, like you said, someone could just keep the money in their safe at home. That's something that you could reach out to an attorney about specifically. But I do know in Burlington specifically, they have to give the security deposit back with interest.
And Empress had a question. Do you want to go ahead and ask it?
Yeah, I have some, like a little something to say because, I'm happy to be in.
Empress, you're breaking up quite a bit right now.
I don't know why. Um,
Empress, do you want to
I-
put it in the chat?
am I still? No, it's a bit much. I just want to talk. Can am I still breaking up? Am I still breaking up? Now I lost y'all for real. Hello?
Yeah,
Okay. Can you hear me now?
you're breaking up a little bit. Do you want to write it in the chat and then and we'll answer it?
It's a bit for me to write. I just want to really say what I'm feeling right
Oh,
now
yeah.
because
Yep, we can.
the truth is this. I've been going through a lot with moving. I moved into an apartment. I have Section 8. I moved into an apartment in Essex for my landlord, and I lived in his apartment for 8 years. And when I moved in the apartment, I took a video of the apartment when I moved in. And I moved out, I took a video of the apartment when I moved out. And the landlord kept my whole deposit. And he, because he wanted to evict me, I had a small business that I started, and it just had started. And he had, when I went to pay my rent in April, he had said, you know, I hear you about your business and that he needs to get more money. And I said to him that day, I was like, April, I was like, I don't really have that much money. The business is not that, you know, not getting any money like that. I just started it. And then the next month, I got a letter in the mail that says, you have 30 days to move out. And I was really shocked and hurt because I lived there for 8 years and I cooked food for this man and his woman. And, you know, it was a good relationship. And then when it was time to move out, I couldn't move right out because I didn't have the money and I'm disabled. I had to get stuff together. So anyway, he said he was evicting me. So he took me to eviction court and I went to legal aid and got help for that. So when I got the legal aid help, the legal aid helped me with the eviction. And then she was like, the landlord asked me to sign a petition that I will not ask him for my security deposit. And I said, no, I won't do that because I left his apartment immaculate. It was very clean. I shot through the curb, everything. And I lived there in 8 years. He never had to come and fix anything in my apartment but once. And that was the sink that was leaking. And that's it in that whole 8 years. And then after that, the lady from the legal aid, they don't help you with security deposit. She has said to me, well, all right, she agreed. I sent her the pictures of the apartment, and she said, okay, so you have to wait 30 days, but your court have to be completely like over the eviction. So then she gave me this letter. And she said, well, you could sign this because you know the landlord was being rude, and the way he was talking to me, she said I didn't have to come to court. That she'll go and she'll bring the stuff. So she brought me this letter and said signed it, and the letter said it was a stipulation that said that we both will pay for our own lawyer fee and no prejudice something. And that was it. And I said, are you sure? She said, yeah, I'm going to send you the papers when you could go take him to small claims court. Well, I did that. I took the papers and I went to small claims court. And when I went in court, it was him and his lawyer and me. And the judge just was like, well, you signed the paper. And so he ruled in the landlord, for the landlord. And I said, but I didn't sign a paper saying that I'll give up my security deposit or anything like that. They didn't want to hear anything. They dismissed it. And the judge said to me, you could take it to civil court. So I went to civil court and I took him to civil court. So now when I went to civil court, the judge said the same thing. But I didn't understand, like the judge was in the back, and there was the two people, I guess the officer and the lady there. And when I came and sat down, they was looking at me and they was talking and looking at me and talking. And then the security, the guy, he got out and went out the courtroom, and he went and talked to my landlord. Then he came back in the courtroom and he said something to the lady, and she said, "Go ahead back there and ask him." So he went back there and talked to the judge, and the judge came right forward and said that I have 3 cases, and this is shouldn't have not been here, and he's sorry, but he ruled for the landlord. And so that, and then not only that, the landlord's lawyer I called him like, well, how is he keeping my security apartment? I was like, and he went to Section 8 now and told Section 8 that I had his apartment so messed up that he didn't know when he's gonna be able to rent his apartment again. And he showed them a picture of like a stove with some stains on it, and the sink that where they fixed it, where it had leak. I had pots in there, so it had the round stain of the pot. That's it. You understand? And then so now I'm dismissed from 2 things, and now I'm stuck with. I go back to the legal aid. The legal aid gave me the paper, and they said this is not a paper saying that you give up your security deposit. So I'm just saying right now I'm in a terrible place because I live off Social Security. This man have this apartment and I haven't done anything, and I have proof that do it, but nobody want to see the proof. That none of the judge want to talk to me, and it's like he's friends with everybody. And even when I went to Section 8, I said, "Miss, can I show you my video, because this landlord took me to court, but he didn't bring none of this to court. He told them that I owe him $1,475, and he kept my $1,100. There's no way that I could have damaged apartment for $3,000 or $4,000." And the lady at Section 8 said she don't want to see no video. She can't see none of that. The landlord brought that, and that's it. And I was like, how is that? So that means I'm a tenant, and I have no rights, no say so. So right now, I just went to court on the 9th. I'm stuck. Like, and I went to
Yeah. Well, thank you for
CVOEO.
sharing your story. I just
Yeah.
this is the best place for talking about very specific personal housing questions, just because I want to keep us on task. But I really appreciate your vulnerability and everything you shared, and you really highlighted an important point of the power dynamic that can be established between a tenant and a housing provider, and all the things you named of having membership in a protected class, and the vulnerabilities that comes with that, whether it's financial or other barriers that you might face. And I'm really sorry that you've been kind of jerked around by all these different groups. And I also admire your ability to self-advocate and all the things that you have been able to learn on this journey, even though it hasn't been fair to you at all.
Yeah, it's
But
not fair to me, but I did go to CVO. That's why I'm hearing all these things that you're saying y'all have help in. That I went to CVOEO, and the lady helped me write the letter, and now she's out on something with her hip or whatever. She won't be back to the 24th. But I'm just saying to say that all these things happen. So then what happens after that? Who do we go through for this help? Because it's not fair. It's not at all. So you saying, excuse me, like you understand what I'm saying. That's not telling me, that's part of everything that you said is something that happened to me, and I need help with it. And it's just like, I don't know. I don't understand. It's not fair at all.
it definitely can feel unfair, and there are all of these rights and responsibilities that tenants and landlords have. And even with the right advocacy and steps that people can take, they still might not receive the justice that they feel like they deserve. And I'm not here to say that we live within a perfect system at all. I'm just trying to inform people of what the law says related to their rights and responsibilities. And there's always room for improvement. And lots of people end up in these really unfortunate situations. So I definitely hear you. And like I said, I admire that you have gone down these different routes to try to support yourself. And like I said, you highlighted a really great point of the power dynamic that does exist, especially with someone when we live in a small state and lots of people know each other and are able to get the outcomes that they want, and how that can also present more of a barrier on someone who's vulnerable. Thank you for sharing your story. And I would be happy to talk more with you personally if you feel like you've experienced a fair housing related issue. I'm happy to talk through that with you as well. And I'm glad that you've already worked with someone on our team. All right. I'm just going to move into the next slide. Related to landlord access and tenants' rights to privacy. So once you move into an apartment, you take possession of that unit and it becomes your home, even though the landlord owns the property. So that means the landlord shouldn't just be coming over whenever they want and coming into your space simply because they own the building. Landlords should only enter the premises for 4 specific reasons, which is to inspect the place, to make necessary or agreed upon repairs, alterations, or improvements, to supply services, and also to show the dwelling to prospective tenants or people who are interested in buying the building. If the landlord does want to enter the space, they have to give at least 48 hours of notice to the tenant, and that they can only enter between 9 a.m. and 9 p.m. They can give notice however they like. It can be verbal, on Facebook, and an email and a text, as long as it's at least 48 hours prior to when they plan on entering for those 4 specific reasons. However, if there's an emergency in the apartment, like a fire or a flood, then they can enter the space accordingly in order to help with whatever that issue is. If someone did experience their landlord coming into their apartment in an unauthorized way, they can send the landlord a letter reminding them of what the law is and the specific reasons of when they're allowed to enter the space. However, if the landlord continues to show up unannounced and saying that they can enter the apartment, tenant also has the right to submit a no trespass order against the landlord as well. Even though they own the property, the tenant has possession of the space, so the landlord can present them with, or the tenant can present them with a no trespass order as well. Tenants have a right to safe and decent housing, which also gives them the responsibility to report needed repairs. Tenants also have the right to safe and decent housing and the right to report if there's habitability concerns in their apartment, and do that free from retaliation. So similarly to if someone files a fair housing complaint, tenants also are protected from retaliation if they file a complaint or request an inspection based on habitability concerns. That protection is written in statute for 90 days of protection after the tenant files a complaint. So if the landlord tried to send them a rent increase notice or send them a notice to vacate within that 90-day time frame, or harasses them, a judge, if this moved into a court setting, would likely see this as retaliation. Safe and decent housing is described in detail in state and municipal housing health codes. Every town has an official whose job it is to come to the apartment and inspect for code violations. In larger towns, there's a code enforcement office, like in Burlington, there's code enforcement. However, smaller towns might need to resort to filing with the Division of Fire Safety, which is the state's agency for enforcing code. Tenants have the responsibility to be the eyes and ears for the landlord since they have possession of the property, since landlords cannot come into the apartment whenever they like. So tenants are responsible for notifying them when things need to be fixed. And it's important to keep record of when they tell the landlord that something needs to be fixed, keeping that paper trail active in case the landlord is unable to or doesn't meet the requirements to make repair. Small issues can turn into large issues. So something like a leaking faucet could eventually turn into a big issue that leads to mold or other things that could bring the apartment out of compliance. All repairs are the responsibility of the landlord to make. However, there is something called repair and deduct, which is a right that tenants have. Tenants have to follow a very stringent process to actually exercise their right to do repair and deduct. So that starts with notifying the landlord in writing that a repair needs to be made, waiting 30 days for that repair to be made. If the landlord doesn't make the repair, the tenant can do it themselves and then deduct the cost of making that repair from the next rent check and then send a receipt to the landlord. There are certain repairs that are not eligible for doing repair and deduct, and that includes anything that exceeds the cost of half of 1 month's rent, as well as anything that requires a licensed professional to come in and make those repairs. So anything electrical, or if an oven breaks or something like that, that requires a licensed professional to make those repairs and wouldn't be eligible for repair and deduct. If anyone wanted to do repair and deduct and had questions around if the specific repair would be eligible, they can always reach out to our Vermont Tenants hotline, just for clarification. It's usually for things like a broken doorknob or a broken cabinet door or something like that. Major code violations, as it states, are a serious threat to a tenant's health and safety. So that can include things like plumbing, structural, fire safety issues, or issues with pests. If your landlord is not making a repair and it creates a significant threat to your health, tenants have more options under the law. They can reach out to their code enforcement office and file a complaint and request an inspection. If their town doesn't have code enforcement, they could file that complaint and request an inspection through the Division of Fire Safety. And both of those entities will come in and inspect the place and create a report that would be given to the housing provider and the tenant if they would like, that names what aspects of the apartment are out of code. And the landlord would be responsible for making a plan to bring their unit back up to code. As previously mentioned, tenants have the right to report free from retaliation. So complaining about a habitability issue and going to code enforcement or the Division of Fire Safety or a fair housing complaint, all of that gives the tenant a 90-day assumption of retaliation, which of course would have to be in the ruling of a judge. So if someone files a complaint and then receives a notice to vacate, and they continue to live in that apartment after the notice to vacate, then the landlord could start the legal eviction process, which would then give the tenant that opportunity to share that, well, I actually filed the complaint and requested an inspection through code enforcement, and then I received this notice to vacate. So the judge would likely see that as retaliation.
If that happens within 90 days, is that what that means?
Yeah. Once again, I'm not an attorney, so I can't give any legal advice. And a lawyer could better assist someone with letting them know like what case law exists and how they could support a tenant if it happened to be 91 days or 92 days when they received that letter. All right, tenants have the right to proper actual notice before a rent increase, as well as before receiving a termination of tenancy notice. So those first letters that people get stating that their housing provider wants them to leave are often called a notice to vacate or an eviction notice. However, they're not an eviction, it's called a termination of tenancy. Only judges have the right to evict. Landlords and tenants can terminate the tenancy of the rental agreement. So proper actual notice includes a written notice that has to be either hand delivered or mailed to the tenant. So if the landlord wants to increase the rent or terminate the tenancy, they have to give the tenant actual notice to do that. And there are various notice periods that are required for the specific kind of notice. So whether a termination of tenancy is based on no cause versus for cause, how long a person has lived in the space, and sorry, I'm forgetting the last caveat there, how long they live in the space, whether it's for cause or no cause. I'm sorry, I'm blanking. That is the determinant of what the notice period can actually be. So if someone has a question around if they've received a proper notice period based on the reasoning behind why their tenancy is being terminated, they can reach out to our hotline. But those are the different reasons for how many days are allotted.
Did you say both of those need to be like a physical written notice?
Yeah, it can't be in an email or in a Facebook message or verbally. If the landlord wants to increase your rent or terminate your tenancy, it has to be through actual notice. all tenants have the right to peaceful enjoyment of their space, which gives them the responsibility to make sure they don't disturb the peaceful enjoyment of other tenants in their home. Things like excessive noise, harassment, or of course, violence or threats towards other tenants could all be disruptions of peaceful enjoyment. Many towns have a designated curfew hours. So it's important that people are aware of those and make sure to keep noise at a minimum after those hours. Smoking in places where smoking is not allowed could be an infringement on someone's peaceful enjoyment, as well as keeping sure that you keep your guests in check and that guests aren't coming in and disrupting the area and the peaceful enjoyment of other tenants as well. Some approaches for problem solving could look like requesting some noise reducing methods from the housing provider. Maybe they can install certain panels or ask the tenant to get some rugs or things like that to help keep noise down. And of course, harassment is never allowed. And if someone feels threatened or unsafe, they can reach out to the police or seek mediation. Tenant responsibilities, the biggest responsibility that tenants have are to pay rent on time. That's the number one responsibility, as 70% of evictions in Vermont are due to non-payment of rent. And after working with certain landlords, one of the things that comes up very frequently is them wanting tenants to communicate as well. So as early as someone can communicate with their landlord that they might get behind on rent, maybe they lost their job or experiencing a medical issue that has kept them out of work, certain things like that, that they're able to communicate to their landlord, and the landlord can hopefully help them create a repayment plan or even point them in the direction of community resources in the community that could support with rental assistance. The second responsibility that tenants have is to follow the terms of their lease, even if they seem unfair. If you sign a lease, you're expected to uphold all terms of that lease. So once again, making sure to keep their guests in check. If a guest stays for longer than what is allotted in the lease, most leases state specifically how many overnight stays a guest can have in a certain period of time. If someone stays for a long time and maybe starts receiving rent at someone's apartment, or they're there for 30 plus days, they could be considered a subletter. Most leases say no subletting or subleasing unless you specifically ask for that. I live in Burlington, which there's a lot of students in the area. So there are some housing providers which will allow for subletting, but it usually requires a lease addendum that the tenant has to sign. So in general, if your lease has no subletting and you have a guest that stays longer than expected, they could become the guest of or the tenant of the tenant. So the housing provider couldn't just tell that person they needed to leave. The tenant might have to go through the legal eviction process to get that tenant out, their now tenant, if they're unable to just talk to their guests and ask them to stay somewhere else. And this can come up frequently as people are in long distance relationships and married couples that live in different states, or people who have adult children that come stay with them when they're maybe in college and home for the summer, things like that. So if you know that somebody is going to stay in your apartment for longer than what the guest time is allotted, then reach out to your housing provider and see if there's something that you can do. Maybe they will have that person added to your lease, or just say verbally, oh, it's okay. But I think it's best to get everything in writing. Also, follow the terms of your lease related to pets, whatever the requirements are for your pets, making sure that you pay your pet deposit or so on and so forth to make sure that you are keeping up with the terms of your rent agreement, and keep the place clean. Housekeeping is important. In statute, it says that tenants are required to not create or contribute to the non-compliance of an apartment. So making sure to keep dishes clean and keep trash out, so you don't attract guests, and keeping areas safe from fire hazards and things like that are all the responsibility of a tenant. And of course, make sure to give proper notice upon moving out. So the housing provider has to give proper notice to terminate a tenant's tenancy, and if a tenant wants to move out, they also have to give proper notice. So even if your lease is going to expire and you're planning on moving out, you still have to let the housing provider know with the proper notice period that you're going to move out. In Burlington, it's generally one full rental period that the tenant has to tell the housing provider that they're moving out. However, in Burlington, you have to give 2 full rental periods. So generally people pay rent on the first. So that's when the rental period starts, when someone pays rent, and then 30 days after that. And here are some resources for folks to reach out to for any more information related to their rights and responsibilities as a tenant. Our Vermont Tenants program solely works with tenants. So if someone is a tenant, they can reach out to our hotline, or also check out the Definitive Guide to Renting in Vermont, which is an online resource that CVOEO co-authored with the Vermont Landlords Association, and it explicitly names what the rights and responsibilities are of both the housing provider and the tenant based on various rental housing situations. And we also have the illustrated guide, which is a less dense version of the definitive guide. And I have many of those here today if people want to grab a copy, and they're translated in several languages. All of our materials can be found online, as well as the translated versions as well. And other resources that we have are our renters workshops, which we teach live via Zoom every month. That's tenant skills, which teaches more expansive information around the rights and responsibilities of a tenant, some of the stuff we discussed today. We also have Finding Housing, which teaches strategies for finding housing and conducting a housing search in such a tight housing market like we see in Vermont. And then we have Sustaining the Rent, which teaches tenants about budgeting and financial tips and building credit and things like that. If people complete all 3 of those workshops and then do a free one-on-one coaching session with one of our financial coaches, they can earn a preferred renter certificate, which can be something they can include on rental applications to show the housing provider that they are well-informed and aware of what their rights and responsibilities are and wanting to have a successful tenancy. All of these workshops can be found on demand through our self-paced platform, as well as, like I said, we teach them live on Zoom, and we also provide translated workshops as well. So people can always reach out and request one of these workshops in any of the languages that are listed there.
Do you ever teach those in person, or are they just online?
We do teach them in person, kind of depending on, usually we collaborate with another group or organization. So if we know that there's a specific number of people that a service provider serves or that a group wants to be a part of, then we would be happy to collaborate with that group to schedule all 3 of the workshops. But we usually don't do them like just kind of walk-in style, because we have them available online and we teach them on Zoom every month. And for fair housing resources, for any legal advice, or if someone needs a referral, we can refer them to the Vermont Bar Association Lawyer Referral Service, as well as legal aid. People can also come to CVOEO Fair Housing Project for a consultation. And like I said, if we talk through your situation and it feels as though someone is ready to file a fair housing complaint, I can send them the resources to do that, or assist someone with filing that complaint as well. And once again, here is our hotline number, which people can reach out to by phone or email. And that's all I have for slides. We have about 20 minutes left of the workshop, so I'd like to open it up to folks if anyone has any questions or thoughts or comments. I already see a hand up.
Hi.
Hi.
Thanks for this. Just confirming that one of the repairs would be like a sink that's clogged. I had sent a written request for that repair 3 weeks prior. And then when I saw my landlord in person, he hadn't responded to the text messages requesting the repair. And then when he came in person, he said, I don't know any landlord that would fix a clogged sink. And I believe that to be untrue.
Yeah. I mean, I'm from an opinion standpoint, I don't believe that someone can speak on all landlords and
Yeah. Tracking with kind of like an avoidance of repairs and such.
Yeah.
That's why I came here, and he did end up fixing it.
Okay.
But I am wondering if it is worth sending a letter to his office, just documenting how long it took, what I heard him say, acknowledge that it was repaired, but just so that,
You could absolutely do that, especially if you think that it's something that could continue. A sink repair could be potentially something eligible for repair and deduct, depending on how much it costs and if that's something you were comfortable with doing. And if you felt like the landlord was avoiding repairing your sink based on membership in a protected class, the varying protected classes, then that could be considered a fair housing issue. And I do see that happening quite a bit where the landlord tenant and fair housing laws can kind of intersect, especially with habitability issues. So like a landlord is refusing to come and fix something, which is their responsibility under Vermont landlord tenant laws, but they're refusing to fix it because of someone's religion or how many children they have or their marital status or their race or something. So I would be happy to support there if needed. Any other questions in the chat or in person?
I just wanted to, I don't have an example, but say there's something in the lease that the tenant doesn't comply with and speaks, is there a process that says that they have to be given written notification? There has to be some kind of a resolution and an appeal process.
Do you mean if there's a lease violation and what the landlord can do?
Yeah.
That is up to the landlord and the relationship that they have with the tenant. If there's a lease violation that a landlord wants to consider a cause for eviction, then they can send the tenant a notice to vacate through actual notice. So it has to be that written notice. And it has to have the proper notice period as well. If the landlord doesn't want to evict, there were some programs that used to exist that supported landlords and tenants with mediation. There's currently no funding for that. But that's where negotiation come in, which is a great point that you're bringing up. A lot of things are not named in statute. So many of the conversations that have to happen between a landlord and tenant are based on negotiation. So depending on what that lease violation is, the landlord could speak to the tenant and determine maybe what's going on, why the thing is taking place, and if there's something they can do to remedy that issue outside of court. Mm-hmm.
Also, I had one other question. I just happened to be reading 7 Days yesterday, and there was a letter to the editor that said that the Vermont legislature is moving a bill to strip tenants of due process rights, age 772.
Mm-hmm.
Is that about eviction or no notice, or do you know what it's about?
Yeah, so that is a current bill that's being proposed by the housing committees in the legislature. Part of it is wanting to reduce the notice periods for certain types of evictions. So that's where people are naming that it is a limiting due process for tenants. But yeah, you can definitely reach out to your legislators to get more information about how that bill is progressing.
We have no cause eviction or no cause termination.
Yeah.
And there have been proposals to change that in the law or even in the city charter in Burlington. So I think it's important, of course, for somebody to really be aware of what their obligations are under the lease, but in the end, if the property, if the provider of the housing follows the rules, they can evict somebody without any cause, right?
Yeah. So no cause evictions can be sent to a tenant if they're not in a lease term. There are some caveats to that. If there's a building sale and then the new property owner takes ownership of the place, there's a little more wiggle room for them to send a no cause eviction to tenants if they don't want to continue to use that property for rental property. But yes, if someone is going month to month, generally someone will sign a lease and it has a fixed lease term, say that term is 12 months and then it expires. then the tenant generally will go start living in the space going month to month if nobody has renewed the lease. And if someone is going month to month, then the landlord can send a no cause eviction to that tenant.
But do you folks recommend that when the lease is finished, that you get another lease?
That's a great question, and it's really based on what the needs are of the tenant, because there can be some pros and cons to both. So going month to month can allow for more flexibility. If someone knows that they don't really like the apartment they're in and they want to find a new one, going month to month gives them less restriction, because if they're in a full lease and they break that, that can come with some financial consequences. However, re-signing a lease for another 6 or 12 months gives them that stability for that period of time. So like it's really just based on what people's needs are.
I had a question. It's not really a question, but well, it is. So one thing I hear a lot, or the housing concern I that's come up recently is that sometimes I encounter people who have there's this friction. Maybe they live in a multi-unit environment, and there's friction amongst the tenants, and maybe one tenant or family is being targeted, and that it doesn't seem, other than the police, right? It doesn't seem like there's a lot of avenues for that. What are some avenues for that to get support around?
Between tenant and tenant conflict?
Yeah.
There are not a ton,
Okay.
There's no organizations necessarily. That's kind of where that negotiation piece can come in, as well as documenting things. Not knowing what the root cause of some of these conflicts can be, it's worth someone still just documenting incidences and where it happened, who said what at what time. And there could potentially be a fair housing issue there if conflict is arising based on someone's biases of someone's membership in a protected class. So all of that can prepare someone to take legal action if that's what it leads to. So whether it's a personal lawsuit or filing a fair housing complaint, just keeping things in writing and keeping a timeline of incidents can be helpful. There is the Community Justice Center that does certain mediation, and you would have to look into that program further, but they might support with tenant to tenant conflict as well.
Yeah. And then one other question I had is, does CVOEO do any, like when you were talking about somebody, not a lot of people are experienced at, renting apartments, right? Like your first lease, right? They might not know like how to do a walkthrough or, things like that. Is there resources within, is that one of the part of like your, how to, some of your tenant workshops that kind of give you some how-to things?
Yeah. Our finding the more expansive version of the tenant skills workshop can touch on some of that, as well as finding housing, which can really support people. And I think housing education can be uplifting and empowering, but I still have to name that the responsibility is on the person who is aggrieved to advocate for themselves. And that's really tough and an unfortunate reality. But I think the more people know, the more it can be easier to navigate certain situations.
Somebody has their hand up. Shauna Green.
That's just showing that the audio is on and talking. I don't know if I'm still sharing my screen. It's not letting me not share.
I put my video on it. I'm just gonna check in with in the chat, make sure anybody.
No screen is showing.
And so anybody have any questions? And And if you, Empress, if you wanted to just leave your name, if you wanted to connect with, give me any of your contact information, you could kind of put it in the chat in a private message to me. And I could pass that on to Kalia if you wanted.
I will, thank you.
Okay.
Any other thoughts or questions coming up for folks? Yes.
Is there a limit on what you charge for a security deposit?
And only in Burlington and Brattleboro. So outside of those two towns, it can be whatever the housing provider would like. It's generally first and last month's rent plus a deposit. So usually 3 times of 1 month's rent, 1 month's rent. Yeah, it can be expensive.
And the returning the deposit within 14 days, is that statewide?
Yeah, that is in Vermont statute.
Okay, but the interest piece is
Burlington.
iffy, just, yeah.
Yeah.
Burlington.
That was an interesting question. I had not thought about that in a while. Yeah, that makes total sense. Yeah. Right, because if you have this sizable, right,
Yeah, 3 months, right?
3 months rent, yeah.
Oh, all right, well, it would just be the security deposit that they're referring to get interest on, right? Not
Yeah.
rent.
No, yeah, I don't think so.
Yeah,
that
just
doesn't make
that's
sense.
just
Whatever
the
they're
deposit.
holding, whatever
Yeah.
they're holding, yeah.
But the move-in cost could equate to first and last plus a security deposit.
Which is a lot, honestly,
Yeah,
to
thousands of
upfront.
dollars.
And I think that's a big chunk. Any other interests around kind of this information or other questions that maybe you are hoping to have answered or?
Just, is there a landlords association and do they offer any resources for any mediation or anything between a tenant and a landlord?
There is the Vermont Landlords Association, which I do believe they support with some legal support. I'm not sure what it takes to actually retain the lawyer who runs it. And I don't know if they have programs for mediation, but they used to. Just last year, they did have a mediation program that both parties had to buy into and agree to participate in, but it was a really cool resource related to for mediation, and lawyers would actually support coming to a conciliation of some kind.
But as far as you know, that's not available anymore.
Not available anymore, yeah.
It sounds like landlords need to be educated as well.
Yeah, I think that could be helpful. Since I think both parties need to buy in, there might have been less buy-in on the landlord side there. Thank you so much. I also do fair housing trainings for housing providers specifically, and we talk more about the responsibilities of a housing provider and best practices as well to make sure that they're complying with fair housing laws. And that also is a training that can be found on our CVOEO website as well. Fair housing for the general public as well as for housing providers if people want to learn more about that.
And do you do anything for first-time home buyers too?
We don't, but there's some great resources in the community through the Housing Trust that have some information there. On our Fair Housing Month website, we did share some upcoming events for home buying 101s. VHFA does a regular home buying 101 webinar. So all the housing related events that people send to us to add to our website are available. And I've just noticed a couple home buying ones. In our financial futures program at CVOEO, they also have, they've been doing some home ownership workshops as well. I think the one that they recently did has already passed, but you can definitely reach out to them. Oh, I see a hand up.
Go ahead, Empress.
I have taken a tenant housing program at CVOEO, but after you take the class, after you finish the course, then somebody from CHT supposed to give you some kind of, I don't know, talk to you about it, and then like your your certificate is good, because I did a tenant program there, and a person from CVOEO was supposed to like call me and talk, and I called them a couple of times and I never did it. So I never got through with them. So that means that I have to take the whole class over again.
So I think what you're referring to is the tenant skills workshop, which people can earn a certificate after they take tenant skills. And there are some housing providers like CHT, Sampling Housing Trust, and Burlington Housing Authority that might require some rental applicants to earn that certificate. So once someone takes the course and they earn their certificate, they can then send that directly to either of those entities to say that they earned the certificate. And they usually require that for rental applicants who, in lieu of having rental references or maybe weren't able to reach out to their rental references or don't have any, they would have them earn one of those tenant skills certificates.
Yeah, that's what I was told when I did take the course and I finished it, but I didn't never get a person like they put a person at CHT, but then they never called, and then I called them, and up to now I haven't, got anything. So I just wanted to know if I would have to take the course again, or can y'all send it to another person? I don't I really, that's my question. Like,
Yeah,
what's
I think
that?
it, oh, I mean, it sounds like there's just that one missing piece. So maybe somebody
Yes.
in CVOEO could kind of see if so it will just help you over the hump of that last step. And
Yeah,
we
what's
have your
the last step?
yeah, that last step. So we have your info in the chat. So maybe we can kind of add that to like see if somebody can reach out. Oh, here I'm telling what your guys are going to do, but
Yeah,
we reach out and clarify for you about that.
If someone took the class via Zoom, then we always send them the certificate in an email, and we usually ask people if they want us to CC CHC or BHA on that email, and then it's up to CHC or BHA to follow up with the person and say, we received your certificate. If you never got your certificate, I'd be happy to look into that and make sure that we can send
Yes.
it to you.
Please, thank you.
And make sure that you can get that to
It is now 2:30.
whoever is looking for it. Sorry, they're giving us an announcement, I think kicking us out at the library.
Thanks, Empress.
Library cards will be issued after that time. Please browse accordingly, and thank you for visiting the library.
But yes, that's through our Vermont Tenants Program, Empress. So it looks like we have your number in the chat, and I'll check to see if I have any other contact information for you, and we can touch base about the certificate.
Okay,
Thank you, everybody. The one thing I want to also, I think a couple of questions, what other programs that kind of specifically target landlords? This isn't quite a program, but in terms of the rental registry and having, properties needing to be inspected in a, frequent, and pass inspection for safety. I mean, that is kind of something that the city does in order to, make sure that rental properties in our community are safe and meet state requirements. But I think it does leave an opportunity to reach out to property owners here, landlords, to offer certain educational things, since we do have a directory of them now. Yeah. Not to put another kind of layer, but it's an opportunity, right? It doesn't necessarily mean we're gonna have them jump through any hoop. It's just more that we can always reach out to people.
Well, it does require, doesn't it, that there be somebody within Chittenden County that the tenant can contact?
Mm-hmm. Oh, yeah,
So
yeah.
It has information.
Yeah, it has information.
Set of
Yeah.
information.
Yeah.
That's required. It's here at the city.
Absolutely, absolutely. So
part of the bill that you mentioned, one version of it did include landlord education. I don't believe it was a requirement, but just funding for it. So depending on where the bill goes and if that gets included again, that would be something that we could start to provide at CVOEO for landlord education. We currently don't have a training that is just about Vermont landlord tenant laws. That is for educating landlords. It's more so just for tenants, because like I said, we just work with tenants for the Vermont Tenants Program.
And then there's flyers on the table that have information about other events for Fair Housing Month. We're hosting a book discussion on Thursday here, same place, at 6:30 from 6:30 to 8. So we'll be discussing the book Brave New Home. So there's lots of other events in the community that are happening. So thank you. Thanks for coming out today.
And I will put our Fair Housing Project contact information in the chat, as well as the Fair Housing Month website for people to check out and see what other events we have going on for the rest of the month.